that you have the right.
Sorry, he says?
You have the right to screen share.
Okay, all right. So I'll try that because I would like to just try to keep it open.
So I'm starting. Is it fine?
I think if everything is set, the numbers are 93. So
If
Yes.
Archana,
Okay.
94 now.
if Archana
Archana
is okay,
ready,
only
then
then
you
start.
can start.
Okay, so give me 1 minute because I would like
Yeah,
to
sure.
just make sure my slides
Yes,
can be
yes.
shared properly.
Yes, yes.
Yeah, take
And
your
I
time.
want to see if I can use the advanced sharing.
You take your time, and the starting will be only after this.
Yeah, I just want to feel comfortable that I can share
Yes,
my
yes.
screen.
Sure, sure.
Yeah, it's not letting me.
No, I think so. We can see the screen being
Yes, there
shared.
is a
Yeah,
screen.
but it's not letting me the option of sharing portion of my screen.
Okay, okay.
Is it possible to talk to
Rahul,
Rahul?
Yes, you can.
If it is not possible, that's fine. I just want to make sure that I can do it or not. Just ask him if a portion of screen can be shared.
I'll ask. I'll
Yeah.
just mute myself for 2 minutes.
Oh, it seems to be okay.
No, it's not letting me share partially, but I should be fine if it's not possible. You can see my slides only, right?
Yes, we can clearly see.
Okay. All right, so we should be fine. That's okay then.
Okay.
I usually prefer to share only my portion of screen, but looks like that's not possible.
Nandini, I think you can start.
Rahul is saying that you can do that. And if you have any problems, you can just WhatsApp him. But he's there. He's there. So he'll help you out.
Fine.
Okay.
I think you can start
Thank you.
now.
I think let's start.
Some stuff. Hello, friends. Good evening, good morning, good afternoon, and greetings of the day. So, as you all are aware, our today's guest faculty is Archana Medhekar. And when I was reading her bio, I was so impressed. And I myself, I'm so eager to listen to her thoughts on online mediation, advantages and disadvantages. Before that, I want to introduce her by reading her bio because it was running in 10 pages. I tried to compress it. Such an impressive bio I haven't seen. So Archana is a distinguished barrister and solicitor and family mediator. Arbitrator practice in Toronto, Canada for last 20 years. Archana is an educator at York University, specializing in complex family issues, gender-biased violence, and the impact of abuse on children. She employs a trauma-informed and intersectional approach to screening for power imbalances. She is an author and has published 3 books and various journal articles. As a dedicated trainer, she provides education to professionals, judges, and the young diplomats at Canada, and conducts international training in mediation and peace building. Archana serves as a leadership team of the United Nations Working Group of Mediators Beyond Borders International and chairs the Women in Mediation Action Groups. She is the president of Ontario Association for Family Mediation, an accredited body for family mediation in Ontario, Canada. Her accolades include Top 25 Canadian Immigrant Award and Volunteer Services Award. A sport enthusiast and a former university cricket player, Archana enjoys playing softball in Toronto, where she lives with her husband, son, and their dog. So over to Archana. Today's topic for Archana is online mediation, advantages, disadvantages. Archana, stage is yours.
Okay, thank you. Rahul, can I actually share my screen so that I can advance my slides, please? Thank you. Okay, probably this is good.
That's fine.
Okay, thank you. Okay, so my greetings to all of you, and thank you for those kind words, Nandini. I really feel honored to join you all from Toronto, Canada, and I know that you have joined from different parts of India and world, and this is my special pleasure because this is my second time to join as faculty for Nivaran's summer school. And I really want to support this initiative. This is amazing. And this year, 2 esteemed organizations have joined and collaborated: Nivaran, the Commonwealth Lawyers Association, and Singapore International Mediation Center. So I want to thank you, all of you, for inviting me, and welcome all of you who have joined from different parts of world for the love of mediation. I think that connects us all. My topic today is enhancing mediation, the critical role of online dispute resolution skills. So my focus would be on understanding the differences between alternative dispute resolution, which is ADR, and online dispute resolution, or ODR. And I will connect that with what skills do we need to build to become a good ODR practitioner. My presentation is approximately 30 to 35 minutes, and we will follow that with Q&A. I will take questions after my presentation is over, if that's okay. And Nandini has promised me to look at the chat and questions that you will share. And I will be providing a copy of my presentation to Santhan, so hopefully it could be shared with you if required. And my presentation will be in 3 parts. My first part would be the tracking of evolution of ADR to ODR. And from that, we can pick up some of the key aspects that make the difference between these 2 processes, and how to build ourselves from the basic foundation of ADR skills. The second part would be how to fit the forum to the fuss, or how to set the virtual mediation table. And the third part would be presenting the actual important ODR skills. So this is actually the 3-part presentation that I would be working with you. Before I go into the deeper aspects of ODR, I just invite you to come with me on a journey to future for one moment. Imagine that we are living in year 2050. You think it's far away? Not at all. It's just 25 years from now. We have witnessed how our day-to-day lives have changed with the use of technology in last 25 years. The leap from bicycle to Mangalyaan or Mars craft happened in my lifetime, and it's huge. I know that after Mangalyaan, there is second Mangalyaan 2 planning, there was Chandrayaan, and I'm closely following that and hoping that this technology advancement means something to us as human race. But as we are all professionals who are conflict resolution professional, what does this leap of technology mean to all of us? Many of us cannot imagine our lives without the internet, but the technology is still young. The internet's history goes back from decades by now. Email has been around only since 1960s. It seems it's here forever. The World Wide Web, or WWW, that we use, it was invented only in 1989. And we have lived through the historic period of that revolution of communication. And from 1989 to 2017, in less than 30 years, half of the world's population was online. As of April 2024, the digital population of the world was 5.44 billion. And this number is number of people who use internet. It amounts almost 67% of the global population. So what was the impact of this digital population increase? Our social interactions, they started to go from in-person to virtual. They included everything from social media, online gaming, exchanging recipes, finding life partners, and so on. And remember, where there is social interaction, there would always be conflict. Another major shift happened, which was through increased economic traffic online. According to Forbes, the global e-commerce market is expected to be total 6.3 trillion US dollars in 2024. Selling product online is not limited to local consumers. Almost 52% of online shoppers report that they shop internationally. Disputes and frauds happen in e-commerce. For example, using a stolen or fake credit card can make online purchase a challenge because it is considered as e-commerce fraud. And approximately 48 billion US dollars would be lost in e-commerce business due to fraud, as estimated in 2023. So given this statistic, it's not surprising that the national and international bodies and the businesses have identified online dispute resolution, or ODR, system design and skill building as their priority. So this field is growing rapidly, and you, as conflict resolution practitioners from various areas of practice, you need to really be ready to serve this ODR expanding aspect of work. And from that perspective, the biggest challenge was internet is intangible. It is borderless in nature. And the practical challenges are questions like who can resolve these disputes, who will be the mediators, what laws would apply, what legal institutions other than mediators would be involved. From the perspective of Singapore Mediation Convention, it's the historic step to the future of commercial dispute resolution beyond the borders. And the Singapore Convention aims to develop the use of mediation in international commercial disputes by making mediation settlement agreements directly enforceable in the national courts of signatory states. So of course, the countries have to be signatories to be taking advantage of that. People are fondly calling this new convention as New York Convention, because if you know and you will recall that in 1958, the New York Convention similarly offered the international framework for arbitral awards. So you will have great opportunity to ride this new international ODR field expansion, which will be really valuable for us in all borderless situations of disputes. Now, looking at the unique features of ODR, as the ODR use has increased, we realize that ODR is different than ADR. I would just tackle two differences. One is it involves communication at a distance. Parties are geographically far away from each other. And second is presence of intelligence of a machine in dispute resolution process. Sometimes it could just be the computer that you're using. Sometimes it could be use of AI or other softwares that you will be making a conscious choice to use. There is a professor at Yale University, Professor Paul Kahn, and he has written really well about the challenges of ODR. And that is the most important one is the erosion of physical boundaries. I really admired this phrase and the concept that what is erosion of physical boundaries? It means that our interactions have become virtual and physical meetings are displaced because of ease of it. But there are many consequences of that, such as the biggest one is confidentiality. It cannot be assured in online participation. As we know, the other challenge is the concept of rule of law. It works over a defined geographic territory, and it's not really available and is lost in the virtual world unless the parties have contractual agreement. So the other problem is the digital divide, or not having equal access to or capacity to technology. And these are huge challenges for ODR, and we need to consider that it has unique strengths and weaknesses or challenges for us. So now we are netizens. Internet is not going away. Access to technology continues to grow, and it will continue to grow. We have seen the revolution of smart mobile technology. I'm sure most of you who are joining have phones with 2 SIMs when we did not actually have mobile phones a few years ago. So that leap of technology has created new culture of netizens. And netizens are, the definition of the word literally is the user of internet who is habitual user. And we are, of course, very habitual users of internet at this time. This is a new cultural identity. We have to keep that in mind. The world is almost divided between people who are netizens and who are progressing to be there. And this is new cultural identity to add in the multicultural layer of people who are involved in our dispute resolution. And the most important aspect is we as netizens need to follow netiquettes, the rules about proper and polite way of communication with other people when we are in virtual world and when you are using internet. So now moving on to part 2, which is setting the virtual mediation table or fitting the forum to fuss. Looking at the very basic processes that are ODR, because sometimes we think that mediation, virtual mediation using the video conferencing, that's the very well-known form of ODR. But there are various other types of ODRs, and there are various other communication types other than video conferencing. So the offered processes under ODR could be many, such as negotiation, mediation, evaluation, binding or non-binding arbitration, or algorithmic resolution and AI applications. But they may not necessarily be synchronous, like we are now virtually joining live at the same time. That is synchronous video conferencing. But there could be chat, which can be simultaneous, but it is written and not verbal. There could be other forms which are asynchronous, and that is basically having discussion forums by email or some other methods. And all of that is constituted under ODR. ODR is not just one aspect of it. And to understand all of that, what we need is ODR mind shift. New technologies have almost disrupted how we do things, and it has changed how we think about what we are doing. And ODR brought that compulsion to have the shift in our mindset. What needs to be done and what can be done is now the question. And the important aspect that we need to think about ODR is if technology is the answer to all our problems. And the answer is tech is not going to solve our issues around conflict, because conflict is about people, not about technology. So the success of ODR depends on how we use technology and not just consider that the tech is going to take care of everything. Success also depends on how you design or your process and use the technology within that process. And that's where the concept of fitting the forum to the fuss becomes really important. If we have to do the ODR well, then we have to match the technology with the need of conflict. And the facilitator, you as a mediator, you and the technology are interconnected. We are not apart from each other. The clients view us as a team. And the tech is not visible. Of course, they can see you. And we have to be very mindful that technology can assist you, but also hurt your process if you're not well prepared. There are different best practices and etiquettes that you can actually apply when you are using the multi-tool approach, which means that you're using Zoom, you might be using some other technologies to support you in your process, you might be using softwares, and you might be actually using aspects of technology which would advance and support the needs of various parties. We have to be mindful of certain aspects, and I'll give one simple example that there are pitfalls of technology. For example, in video conferencing, if you're doing it by Zoom or some other platform, there could be screen fatigue. So you have to give more frequent breaks if you're working with the parties, particularly on emotionally draining aspect of resolving conflict. So these are the things that we really need to plan when we are designing our process. The most important aspect is when there is ODR, we are not the only ones as a third party. You might have heard the concept of mediation triad, where there are two parties and a mediator, or multi-parties and a mediator, and there is a dynamics playing out between these parties. So when we talk about ODR, there is a concept that is important, and Colin Rule, who is the pioneer of mediation field, he actually talks about the fourth party and the fifth party. ODR and ADR, he says, are fundamentally the same things because they are both designed to resolve disputes. But ODR involves new and different tools. And from that perspective, he says there are two additional participants involved in ODR. The third party, of course, is a mediator. And the metaphorical participants known as fourth party is the technology itself. And then there is a fifth party, which has become a real crucial conversation around ethical use of ODR, which is the role of the fifth party. People who are designing the tools that we are using, who are developing these tools and providing us that technology, how that is developed and how it is impacting our processes, such as OI, ChatGPT, is it sensitive to people's cultural and other types of needs, is a huge debate that is taking place at this point in time. So let's look at the fourth party, because that is something which is crucial for us to work with this fourth party for our advantage in the system as our process. So the medium of internet is resolving disputes, and it explains the difference of ODR and ADR. So ODR relies on this fourth party, which is technology that assists us as practitioners of ODR other than ADR. The role of third-party neutral can change according to the context. It can be same as the fourth party. So we can change based on the needs of the parties and context. We have to see that the fourth party will come along for that. In most ODR processes, where there is a fourth party or technology, it does not replace the third party. There is a debate if that should happen, if the AI should replace the mediators and there should be absolutely manless mediation or conflict resolution. And that's a controversial aspect. There are certain examples where the bots are being used to resolve disputes, but they are, of course, very robotic. So where there are complex issues, human involvement is definitely important. In face-to-face mediation, what we understand is words and body language is important. But when there is a screen-to-screen conversation, which is happening right now, which happens in ODR, then the visual dimensions and computer screen becomes the communication element. And that's why technology is very critical in ODR. It is the form of our communication. The most challenging thing about ODR is actually balancing the integration of human element with the technology. And if we take the idea of fourth party seriously, then we need to recognize that ODR is not just the neutral tool. It creates new dynamics, and we as mediators have to develop skills to manage it better. So once the process moves online, its nature begins to change. In reality, technology, it's slow in moving us away from models that we know, the values of ADR that emerged in 70s and 80s and that are still prevalent today. The lines between ADR and ODR are blurred, and soon it's hard to tell which one process we are following, ADR or ODR, because they're almost overlapping each other. So as we have said, integrating conflict resolution and technology, what is the technology? Sometimes people are using regular phones. You can call the online commercial provider that you are using, such as Amazon, and talking to them on landline, negotiating with them, the return label did not come. So all of that becomes the technology. Of course, cell phones, then teleconferencing, email, text messaging. There are some chat bots. As you go on some websites, they will take over. There are other text-based applications, or there could be, of course, video conferencing, or sometimes there are platforms or applications that the businesses have developed themselves. So all of this is form of ODR. We just need to name it properly because we think that ODR is something that takes place only in a formal setting. So we are all concerned about the crisis of access to justice. It's at the tipping point, particularly so after the pandemic. And it's the socio-legal crisis of our time. It is not just the legal aspect. There are so many other aspects that are interconnected with it. With over 70% of legal needs of people not being met, which is called as the justice gap, people are concerned about waiting for long times, spending lots of money, and to resolve their disputes, which need to happen timely. So unless we as conflict resolution professionals take new approach in delivering legal services, the public that we serve will start finding their own answers. And sometimes they can actually choose the risky options to get service from unregulated professionals or substandard service offered by people who are not accredited. The ODR offers the promise to holistic approach and deliver time and cost-effective services. And if it is done right, and that's what I'm underlining, if done right, it could become the means of providing access to justice. The International Council for Online Dispute Resolution, or ICODR, has developed the global standards of technology-assisted dispute resolution. It includes diagnosis, negotiation, mediation, arbitration, and even the courts. As there is a rapid growth for ODR, number of cases worldwide, it is vital that we establish ethical standards for ODR services. It includes many areas that you will find helpful to build your own skills and develop ethical practices. I have included the hyperlink of those standards in the PowerPoint. You can try to look at it. If not, you can Google ICODR standards and it will come up. It focuses on primarily competency of ODR providers. We must have relevant expertise in dispute resolution, legal, technical aspects of execution, the language, and culture as well. ODR services must be timely and use participants' time usefully as well. So then it becomes cost effective. So now moving on to our next phase, which is the part 3, which is what are the crucial practitioner skills as ODR practitioners. So as we are quickly moving from extension of ADR and ODR becoming its own discipline, it's not clear what is the reason for expansion, but the prediction is there are 3 things that are crucial for expansion of ODR. Number 1, there has been change in view towards online mediation and digital communication. The accelerator, of course, was the pandemic. People started seeing the online dispute resolution more favorably because they realized it's powerful. Secondly, there has been development of more powerful softwares. And thirdly, ongoing dissatisfaction with the alternatives that are available, which is always seen to be the main aspect, which is litigation. And all courts all across the world have really seen huge backlogs in their system, and people are trying to find alternative ways to overcome the challenges and finding someone who can assist them to resolve their issues. So now looking at the adaptations that are important as skills of what you have or possess already as traditional mediators, how we can use that toolbox as a foundation to build further on that so that we can become good ODR practitioners. So ODR offers unique challenges, but you will still need your traditional mediation tools. And those could be, how do you screen? Whether you can recognize the power dynamics, the power imbalance, can you properly balance that power imbalance? How do you build rapport with the parties? How do you build trust with the parties? What would your process design look like? Do you know how to caucus, or how do you know, and do you know how to do the safe termination? These are some of the examples which come from the standard traditional ADR field. They're all applicable to ODR. You may find some of them even more important and useful than the face-to-face mediation in ODR. So they are all useful, no time yet to move away from those skills. Now looking at the pros and cons, very overview way, given the limited time that we have, is what are the pros and cons of virtual mediation? Let's start from cons or challenges. The most important aspect, it is reported that 80 to 90% of communication is nonverbal that we have. And you can lose out on that nonverbal cues of the body language in ODR. It has less tone and finesse. It is less formal, which means that sometimes it means less structure, which might be the need of mediation process for the parties to participate fully in your mediation. It is possible that the parties can have more aggressive behavior because the conflict can escalate rapidly, and there is no means, unless you know how to handle that de-escalation, it could really go south. If there are technical issues, that could be the interruption in your process. So we will talk about how to handle these challenges as well. Sometimes ODR means that the parties and mediators can be disengaged. They are not on the same page. And the creative problem solving that's required, and the voluntary participation of the parties doing no harm. All these principles are at stake sometimes when people are not engaged well. There could be a risk of being non-inclusivity as a result of that. Sometimes, again, doing multiple things can be exhausting as to the parties or mediator. Now, looking at the benefits, there are, of course, many benefits of ODR. It's said that it's a conference table set in cyberspace. I love this metaphor. The main advantage of ODR is accessibility, low cost, and speed of communication. It is less formal, and that could be advantage sometimes, particularly in mediation where people have to be relaxed and be themselves. There is no need to reinvent the wheel for us as mediators. We already have the skills, and it would allow us to use the skill set we have as face-to-face mediator to add some twists and make it necessary to use the technology efficiently and become ODR practitioners. Mediators will have to be tech savvy. They have to be skillful in helping others find their way around the technology. So we have to work closely with our clients who would participate in our process as ODR and making them feel at ease with it. Once that happens, you can cruise in ODR. You can conduct more mediations. So it's, of course, if you can offer more mediations, then you can resolve more disputes and you can serve more clients. I was watching the recording of the inaugural aspect of this summer school, and one of the speakers was actually, in fact, doing a ODR process. I think he mentioned arbitration. He participated in this process in the summer school and he went back to his work. So all that flexibility that it offers, it is amazing. It's available 24/7, and it removes the physical boundaries or barriers. And sometimes being on a no man's land, you are not at mediator's office or any of the parties' lawyers' offices and think that, oh, because of the use of their office, someone could be, in fact, biased towards them. So all of that is removed because sometimes perception of bias is a challenge. Now, looking at ODR practitioners' core skills. I'm a science graduate. I like formulas. Sometimes it's not easy to have formulas in our lives, but ODR skills are ADR skills plus technology plus new competencies. And becoming tech savvy is a process for us, although we think we are using computers and mobile phones for a long time. When it becomes your core aspect of the process, you have to invest so much of time and energy in learning that so that it does not become hindrance. But I would say that if you are basically not familiar with the technology, it can get in your way. So anticipate frustration. Don't let the perfect be the enemy of good. And the new dimensions are extremely important around privacy, security, data protection, AI, and ODR ethics. So how do you keep your notes? If the participants in your process are recording with consent or surreptitiously, you must have heard that sometimes during the pandemic, the practitioners, without telling them, faced that the clients recorded the process and then they put it on social media criticizing. So having proper contractual understanding, common understanding of parties that there will be no recording, or would there be recording? If there is, who would be having access to that? All of these are best practices. So use of technology is not the end of it. We need to think about all these best practices as a professional to protect ourselves and practice safely. Sometimes having pre-mediation situations as explained to the parties is important. And if you're thinking about offering ODR practice services to the clients, it is important that you consider that people sometimes use various things to prepare their parties to participate in the process. You can have a short video conferencing meeting with them to discuss how your mediation process will work. Sometimes having a tech check, having testing of the technology before your mediation session becomes really crucial. Sometimes the clients have not downloaded the Zoom client on their mobile phones, for example, if that's where they're joining it from. And having that tech check will save you a lot of pain and energy wasted on the day of mediation. So having that tech check can actually go a long way. You can send some introductory recordings. In my practice, I have Q&A handouts and some links of videos that they watch in advance. So when they attend my process, they already know what to expect. And I always have tech check with them so that they are prepared and we are all on the same page. Sometimes it is better, and that's what I do in my practice, that what are the best practices for communication, how to be brief and firm, and BIFF response, friendly but firm. All of these things where people who are high conflict people, or if there is escalation, what is beneficial in mediation is usually useful. So client education for technology and communication protocols will go a long way, even in ODR. So I would say that we are educating our users for three things: transparency, efficacy, and fairness. And those are the cornerstones of any problem solving or justice related process. And the best thing about using Zoom or any virtual platform is you can have a non-verbal feedback. People can raise hand, they can go thumbs up, thumbs down, they can say, please go slower, I'm going for a coffee break. There are various aspects of non-verbal feedback. You can creatively incorporate that, educate the clients about it, and they will be happy to use it, and that will take your process move smoothly in the actual delivery of services. Now, the virtual etiquettes for mediators, it is important that you create your own virtual etiquettes. What are the norms? What are the protocols? And what are the rules? And these are the best practices. I always suggest that tell and show your participants that you want them to participate or behave in a certain way, and model that behavior. If they see you doing that, they will follow your lead. And if you bring that positivity, that would actually enhance the process. You show them through your model behavior that how do you wait patiently to speak for their turn, and how to be respectful to the others. And you being respectful to them would be the starting point. Now, how to bring the positivity? Sometimes that becomes a challenge. And of course, this is a whole list of things that we can do, but you can create the atmosphere for productive discussion. At the beginning, encourage the parties to agree what their goals and ground rules are. Take insight approach. I'm sure that you have heard about insight approach, helping them understand what the other party is saying. So listening to understand, not listening to react. Make the process futuristic. That's why mediation works. And how sometimes you make it futuristic will display the enthusiasm and optimism in behavior of parties that would be great for problem solving. So I would say that you would have to manage three things for being an effective ODR practitioner. Number one is managing relationships. So for that, you're managing relationship by creating trust, by de-escalating and promoting collaboration. Secondly, managing the message by listening, asking good questions, reframing, and gathering key information. And the key information not only for you, but educating the parties about their interests from each other's positions. Thirdly, managing time and process. That you can do by creating a schedule, controlling the speed and pace, sometimes helping them with the tech, regular check-ins, and the most important thing is ongoing screening. Are they feeling safe in the process? Are they feeling comfortable? Is there anything that needs to be changed so that they feel that they can fully participate in your process? If the disputes are complex, what are the practical considerations? And you would think that it's very simple and it's no-brainer, but believe me, unless we think consciously about it, it would not happen. Sometimes it could be as simple as, are you going to use laptop, desktop? You need 2 monitors. Which monitor are you sharing with clients? Which monitor you are actually keeping for your internal aspects? Who is going to take notes? Because taking notes is important for your best practice aspect. How are you going to deal with documents? Are you going to keep them all scanned and saved in some Dropbox location? Or you are actually going to keep it and shred it once the parties provide it to you? And it should be part of your contract to mediate. How are you going to share the screen? How are you going to manage exhibits or things that parties share so that there is a common visual available for both of them? Are you only virtually facilitating, or you are going to have hybrid approach? In some of the cases, you can have the mix and match approach. How are you going to manage the participants in your virtual process? Are you going to mute them if they go really ballistic about things, which is of course rude, but sometimes necessary? Are you going to introduce simple protocols such as raising the virtual hand? What it does to you as a process facilitator is that tile or that person goes on the left-hand top corner for you, and you can invite that person to speak. And that is the way of handling things and de-escalation sometimes as well. Can you create the breakout rooms? What are you doing in breakout rooms? Can you give instructions while you are in the plenary to the breakout room conversations? All these are important skills, and handling the tech issues without disruption in the proceedings can become a smooth aspect, particularly if there are multi-party mediations that you're offering. Now, the biggest thing is virtual trust and rapport. It's important. It will go a long way if you will be the human. Be authentic, be yourself. Sometimes engaging in a small talk, sharing something about yourself, showing them that you're human can help. Show them empathy. And sometimes that is lost in ODR. You take it too technical, too transactional, and parties fail to engage in the process because they feel that they are not being treated respectfully or as a human. Even the email communication, I've given some example here, which I'm not reading, but in your email communications, sometimes you can remember to show that you have a human side and affectionately addressed the client about some of the human aspects of things. And you will see that the positive spiral would take people responding in a positive way. So it's about us as mediators creating that positivity in our process. And I would say brag about the effectiveness of ODR. And it is sometimes people who have not participated in the process can be not sure whether it works. So you can always tell them that it has worked virtually for other clients like them. Focus on hopes for the future again, rather than the problems of the past. And although the settlement is not reached, the research has shown that when mediators drop the term settlement into their introduction, the parties are more likely to view the process as the purpose of conversation being resolving. So consciously reading some of the research and implementing that in your practice can be really useful. Now, of course, you'll have some more details about communication as you go along in the summer school. But the most important aspect of on-screen presence or non-verbal communication is tone, which is a paraverbal aspect of it. It's not about the words you use, it's about the tone, because the tone matters. Your audience is measuring your emotional subtext. Sometimes your own mood, sometimes if parties or you are frustrated, angry, or bored, all of that is going to show in your process. And remember that there is a negativity bias. It is one thing you say to them, the parties would remember one thing where you slipped. So, of course, you are human, it is possible, but trying to keep it in mind and bringing the positivity consciously is crucial in ODR as well. And preempting issues of virtual trust building is really crucial. And as simple as having a backup plan for tech issues could go a long way, because if there is frustration, the parties can really easily abandon the process and say, it's not working for me. Most important aspect is communication skill for de-escalation. It is important in ODR because if it escalates, it will go very negative spiral very quickly. Always remember that emotions are involved in ODR, and parties have difficulty communicating means they are really deeply involved in the conflict, which is making it difficult for them to be objective. So effective communication is resolving conflict key, and keeping that in mind works in here. And I'm just going to very briefly discuss about the reflective listening. I'm sure that you have heard about deep listening. It means you follow the body language as well. But the use of reflective listening technique is important. You can see the formula, which is in the blue on my slide. It involves paying careful attention to what the person is saying. So you attend to their need and then see what's the feeling and what you have to convey that they are being understood. And that is the importance of reflective listening. It goes a very long way in ODR. One example is basically, you seem to be saying that you feel afraid of losing your job and not being able to pay mortgage installments on time. So it has three components. It has the opening. You are talking to them that what you heard, rephrasing or paraphrasing. You actually tackle the issue of feeling or emotion. You name it. So the saying is, you name it, then you tame it. So if you name that you're feeling so and so, and then you say that I understand that you're feeling so and so because it's about something, because it's because of something, it is something when something triggers them. So all this conversation, there are various mix and match things you can fit into this formula, but this works really well in ODR because you're actually giving the parties a clear signal that you understand what their needs are. And always remember the importance of first impression. You will be judged by that, how you present physically, how you are dressed, how quickly or slowly you speak, your volume, your tone, your posture. And although we know that there is no direct eye contact in ODR, sometimes looking at the camera, looking at the screen could make people feel that you're talking to them. And if you really want to show affection, you can come closer to the camera and show that through your body language that you're actually trying to come closer to them through the ODR as well. And I'm again not going so much into the detail, but you must have heard about the 7%, 38%, and 55% rule, which is Albert Mehrabian communication model. Words represent only 7% of our communication. It is mostly the 38% is tone of voice. It counts the most. And the remaining 55% comes from nonverbal sources. It could be body language or facial expressions. So keeping this in mind, it is so important in ODR, where we are otherwise going to lose a lot of data that as human beings, as socialized human beings, we know how to get the cues and behave. And from the research, I'm just going to recite in the order what is effective communication all about. One is nonverbal communication, paraverbal or tone that allows the parties to engage with you, active listening, adaptation for particular audience, going slow, going fast, what technology, that adaptation is crucial, and then the verbal words. So in that sequence, in that order, the impact of ODR becomes positive. If these things are missed, that could be a problem. And as I said, sometimes you can show affection by coming closer to the camera. Sometimes the same thing you can use to de-escalate. It's easy to use your hand coming closer to the camera, and with a calm voice, you can say, please let me finish, then speak calmly, and then invite the parties to share. This is a very simple trick, but as a mediator, that would give some guardrails for your process. And again, on screen, it is important that you make people feel people that they are heard. You must have heard the saying from Maya Angelou that people forget much of what you say, but they will remember what they thought your attitude was, how you treated them. So it's not about what you said, it's about how you said it. And that is crucial for ODR. It might sound like simple communication aspect, but it goes a long way. And finally, for engagement of the parties, it is important to see if you are being mindful or your mind is full. And same goes for the parties as well. What's the difference between these two things? Of course, we know that mindfulness is staying in present, participating fully. But the problem is if our mind is full, if we are distracted, if we are using cell phone, if you're checking emails, if you're talking to someone while participating in the process, if you're thinking about the past and the future and not in present, all of those things show that the mind of the mediator or parties is full. Our mind is a great tool for problem solving, but it's not great in settling in one place. So creating some virtual rituals to ground the parties and yourself and fully engaging is the key for ODR. So ODR, or the technology, is not on its own successful or access to justice tool. It is how wisely and carefully we use it that will define how far it would go. So with that, I think I'll pass it on the floor, Nandini, back to you. I'll stop sharing. Thank you.
Thank you so much. Now the floor is open for question answers. And Archana, your this presentation was so technically advanced and so intriguing that all of us are just struck to the screen. So we will quickly ask questions. So anybody who wants to ask question, I think it's better to raise your hand so we can quickly do it. At least 4-5 questions we can take together.
Nandini, can I ask a question? Nandini?
Yes, please, sir. Yes. Yes, sir.
Archana, I've got a question. Whenever there is a online and there is a settlement is arrived at, that settlement has to be, Archana, am I clear to the question?
Yeah, I can hear you.
Yes. Whenever there is a settlement, and a settlement has to be signed, because in India, normally it is through a court annexed mediation, through a court, because we have to send a report to the court, the settlement to the court. At times, both signatures, if online a settlement arrives at, both parties say we want to sign. A option is we have a digital signature. Suppose one party is physically present. He says, I'm ready to sign. But he is not accepting that other party signs a digital signature. What possible could be the option which you suggest?
So I want to go to the core of this question, which is what is the meaning of mediated settlement in terms of formalizing an enforceable contract? So I would say that because mediation is a voluntary process, unless the parties are ready to sign on the dotted line, they are not compelled to do that. Although it sounds very frustrating, I think that is one of the things we have to keep it in mind, that it's their life, it's their choice, whether what they agreed in mediation, whether they want to abide by that in the final agreement as a contract or not. And because of that, usually the role of a mediator is to say that when I'm giving a report, it is mediator's understanding of what parties have come to an agreement in the session with us, in particularly closed mediation. But whether they get the proper legal advice and want to keep those terms for final agreement purposes or even on interim basis, it's a voluntary process. So they would obtain maybe advice from their lawyers, and if what they agreed is not something that their lawyers support that for the purposes of settlement, then they can withdraw. And we have to give them that respectfully. But of course, sometimes signing digitally or signing in person can be the technological challenge. It's not about intention to sign or not sign. So for that, you can, of course, use the technology. Now, Adobe Acrobat makes it very easy to have remote signing. There are many other softwares that would allow parties to digitally sign. And then having someone give them advice before they sign is, of course, always a good practice, having ILA or independent legal advice. But I would say the differentiation between whether they intend to sign the contract based on mediated settlement or not is the crucial aspect of that.
Thank you. Thank you.
Thank you.
Archana. Thank you, Archana.
There is one very important question in the chat box by Mr. Chitrapu Kamaraju. He is saying, Madam, could you please elaborate on what are the new standards, developing international standards to address the tech solution, cultural competency training, legal, technical, and enhanced communication tools?
That's a wonderful question. I actually wanted to spend a little more time during my presentation, but it could be a topic of its own. The challenge is because we are spread all across the world and we follow different best practices. So there needed to be something that would tie us all together and say, okay, this is the minimum standard that we would offer the parties. And that is something that you're talking about, the organization that has created it. It's, of course, not mandatory, it's advisory. But if you will look at those standards, they are from various angles. From legal standard, it would say that you have to consciously think about the legal parameters of the countries that the parties are participating from. Because ultimately, as Mr. Sharma's question, if the decision that they have made or the settlement they come up with is way beyond the legal framework, and if their intention is to formalize that, the court may not want to accept it if the terms are not properly drafted. So keeping that framework in mind, and if people are coming from two different parts of the world, two different countries, it means you have to keep in mind that both those countries' legal framework is considered. The challenge is when we talk about culture, and the culture is different in all different parts of the world, and where one party is culturally, because that's the communal identity that we have. Sometimes that's expressed through food, sometimes that's expressed through the way we dress, but it is not necessary that we know someone's culture, and asking the questions around that respectfully is what is suggested in those guidelines. That you cannot really learn about every culture on this earth, but you can be at a point where you respectfully ask questions, be open-minded, and ask people what is important to them and why that is important to them. And listening to the listener. Again, that concept is crucial. You are listening to what the party is saying, but at the same time, you're keeping an eye on the other party who's participating, who is impacted by what's being shared. And when there are intercultural aspects, when people come from different cultures, they speak different language, they think differently, bringing them on the same page requires us in opening up that space more for that conversation, educating them. In terms of technology, it is crucial that if you are going to use certain technology, you already have shared that with your clients, that this is the technology I'm using, this is a safe technology. A lot of times we use Zoom. Nowadays, that's become the tool, but there are some service providers, private service providers, that would offer you their own platform which has been developed for giving professional services. And those are very commonly used all across the world as well. So if you are participating in that, what that platform looks like, what are its limitations? Because the privacy and confidentiality is the huge challenge for ODR. It works until it works. If someone starts becoming destructive in your process, you can't really stop someone from recording. It's so easy to have a cell phone besides you and they say, I'm not recording. You might have heard about softwares. I'm going to give you an example of Otter AI. If you actually have Otter AI on your cell phone, it's going to record everything, transcribe it in live timeline, and someone can use it for something negative. And it literally records everything word to word and transcribes it. It could be a strength until it could be a strength. So all these parameters of what you are using the chatbots? Are you using the AI? You have to inform your clients. And these standards suggest that what could be the best practices. And it is two-way. It is really amazing to read how in-depth they have gone to develop these best practices. One is, of course, how do you serve the clients? How do you make it the process best for them? But at the same time, how to protect yourself as mediators, as professionals as well. So I think it has to be seen both ways, the client facing and the professional facing, and it has to be a balance of both of that. So you will actually see they have given specific examples. There is a link in my PowerPoint, and I hope that you can go through it and make it part of your best practice, please. That would go a long way. Nandini? Okay, looks like we lost Nandini. Okay, so why don't I take the questions from people who have raised hand until she joins us back?
Yes, you
Okay,
can.
so, yeah, okay, thank you. So, Afsa? Okay, so maybe you're saying I should go to Suvarna?
Yes. I've got the
No,
access.
you can speak? Okay,
Yeah.
thank you.
Good evening, and I'm Hafsa. I'm currently a student, and thank you so much for the wonderful session. So my question actually follows up the question which was asked earlier. So when different cultures are involved, the best practices for different cultures are completely different. So as a mediator, do we go to the extent of bringing in another person from the, say, opposite side person's culture to ingrain the practice and go in depth of making the best practices as, like, how do I, like, as easy as possible? Because at large it seems like there is a lot of best practices available and you have to ingrain everything in that one mediation case. So how do we go about that cultural differences?
That's a really good question, because unless parties feel safe in our process, they're not going to fully participate. And the process has to be voluntary. As we know, mediation is a voluntary process. And our biggest principle is do no harm. So if we cannot help the parties, at least we should not harm them, right? So we are keeping that in mind when we are offering them our services as mediators. These are basic principles. Now, culture is really important because it can be shown in many ways. Again, it is very simple how people dress, sometimes how they would speak, which language, but culture is not limited to that. Culture is really how people think about the problem and what would be the solution which will be sustainable and work for them. So understanding their culture from that perspective is important. And as a mediator, of course, as I said earlier, we cannot learn about every culture, but we can be open-minded and respectfully ask the parties what is important to them. And the beginning of all of that starts from our intake and screening process. And usually we have that intake screening process, which is confidential, which is one-on-one before you bring the parties together. So during that session, use some of your skills to know more about that person, what is important to them, what culture, are there any barriers? And if you see that some aspect after you meet the other party is going to be a challenge in the process, then in your process design, you can always bring various types of people who would support the process. Of course, both parties have to be on board for that. And the simple example could be if there is a language barrier, right? You are going to bring language interpreter. Everyone agrees with that. But if there are other types of barriers, then what kind of support you are bringing becomes the creativity of you as a mediator. And that could look like bringing a cultural interpreter. That happens a lot of times. But again, if you are bringing an additional person, how would they participate? What are the confidentiality aspects when they participate? And they have to be agreed upon by both parties. If not, then you had to think about balancing the presence of that additional person who probably be in a shuttle way participating in the process, which becomes really a challenge. So thinking about that as it should support your process, it should support the parties, and they would not be spoilers. You might have heard the concept of a spoiler. Someone just sitting as a support person could itself be a spoiler, right? So we don't want to bring our spoilers to think that they are going to support us to know more about certain thing, not just the culture, but other aspects of that. So, and that's why we are talking about technology as a fourth party. We are thinking so delicately about the impact of the softwares that we are using, right? So we have to be really considering very deeply in our process design that what would be the impact of that.
Yes.
Archana,
Thank you so much.
Thank you.
Archana, our sincere thanks for your exceptional presentation on Nivaran's platform. Your insight and expertise made a significant impact today, and we are grateful for your valuable contribution, taking your time and sharing your knowledge with all of us. I hope that in future we want to have a one-day seminar with you, definitely. Thank you so much from all of us at Nivaran. Thank you.
Thank you. Thank you so much.
There's an announcement for tomorrow. So our tomorrow's guest faculty is Honorable Lady Justice Joyce Aluch. She will be talking on ethics and ethical issues on mediation, confidentiality, neutrality, and self-determination. And Mr. Nikhil Jain, mediator, will be the host. Do join us tomorrow. And signing off from here, Nandini Gore. Thank you so much to all of you. Thank you, Archana, again.
Thank you,
Thanks,
Archana.
Archana, for your time. Thanks,
Thank you,
Nandini.
Archana, for your.
Thank you so
Thank you
much.
so
My
much.
pleasure.
Thank you so much. Thank you so much.
Thank you, Santan. Thank you.
Thank you. Thank you.